Yeah? Okay. Okay, so we're going to move on with our next presentation today. And so a little different messaging, as I alluded to in my comments a moment ago. Risa Kirshblum and I are going to talk about collaboration between lawyers. And really, the idea behind this presentation came from how can we get these cases done more expediently, with more cooperation, and as you'll see as we go through, there are absolutely ways that as plaintiffs' counsel, we have things that we can do to make this process go a whole lot smoother and a whole lot quicker. So Risa is a partner with Lenczner Slaght. She does represent physicians through the CMPA in their defense of medical negligence actions. But I need to say, and I know that Risa will also confirm this, everything that she says today is Risa's an individual lawyer and what she stands for. It's not a CMPA approach, a Lenczner Slaght approach, it's Risa's approach. And it's important, you know, everyone recognizes that. And just like plaintiffs' lawyers and plaintiff firms, you're going to get a whole variety of approaches and strategies. Same applies to the defense side, whether we're dealing with hospital counsel, physicians' counsel. Individual lawyers have a whole lot of autonomy in these cases and how they're prosecuted. And so I think that's really important to recognize. So in terms of the flow of our discussion today, and we did leave time, hopefully, for audience questions, should anyone have them. But we want to sort of start from the initial stages of an action moving forward and the things that we can do or shouldn't do, as the case might be, to help move these cases further. One of the things in the initial stages of a file, when I'm initially starting a file, I will always prepare a full set of medical records disclosures and send them immediately to defense counsel once I know who it is. I don't hesitate. And I had a lawyer come to me who was just starting up their medical negligence practice and say, so, you know, I am having counsel ask me for productions. I served my claim, but, you know, I don't think I should do that, right? Because they're going to take advantage of these records. They're somehow going to trick me. And so I should hold them back, right? Put them in my affidavit documents. And I sort of laughed and said, absolutely not. They need those documents to defend the case. They have to have them, and it's just going to slow everything down, and it's going to tell them you don't know what you're doing if you're holding back those records. The hospital has access to records. They are the healthcare custodian for any in-hospital care. Individual physicians do not have access to those records. They need to obtain them through plaintiff's counsel. So Risa, when we're talking about initial stages and things that counsel can do to get these cases moving smoothly so that the relationship starts out on the right foot, gets things rolling, can you tell us what things plaintiffs' lawyers can do, and conversely, what not to do and what you've seen? I'm sure you've seen a thing or two happen that thwarts the process getting off on the right foot.
Sure. Well, I mean, let me just speak first to what you just said about the lawyer coming and thinking that somehow they were going to be at a disadvantage if they, you know, give the defense the brief. What I can tell you as defense counsel is that when I have counsel on the other side who comes to me as soon as I've been retained and says, okay, I'll get the brief over to you, and it's a brief that has, you know, all the medical records and a lot of the damages records and the tax returns and everything that we're going to need, and it's all indexed and all of that. What does that say to me? It says to me this counsel is ready to go. They know their case. They're prepared to invest in getting their stuff together. And so it's a case I've got to look at very seriously. And so I think it's the exact opposite of what that young lawyer's reaction is. And I'll tell you a story that happened to me a long, long time ago. There was a lawyer on the other side. I sent my usual, here's my notice of intent to defend. You know, I'm going to investigate. It's going to take me a little longer than 30 days probably to get you a statement of defense. Please send me whatever records you have. And I got back a very nasty letter saying, you'll get the records when we have affidavits of documents. And I thought, okay, that's stupid, but fine. And then he served an expert report that made reference to a whole bunch of a whole bunch of records that he had. And so I wrote again saying, okay, I have your expert report. Can you send me the records that are attached? And again, he said, I had those records only for the purpose of briefing the expert, and you'll get them when I get the affidavit of documents to you. And then eventually, when it was time to send the affidavit of documents, he sent it to me, and all of those records were listed in Schedule C. And so I wrote a letter saying, where are the records? He said, well, I destroyed them because you refused to pay for them. At some point, he had said, I'll give them to you if you pay the cost that I incurred to get them. And so, I mean, I gently said, you might want to consult with a colleague about what to do here. But, you know, what that said to me is this is somebody who is not ready to go, doesn't know his case, doesn't know his obligations either, but it's not one that's going in the I better look at this very seriously column, right? So I think it's the exact opposite of that reaction, you know. The quicker you get me the records, all of it, not just liability records, not just medical records. If you've already gotten your tax returns and employment files, what are you gaining by not sending them to me? All of that just delays the progress of the case.
Now, let's talk for a minute about opportunities potentially for pre-litigation resolutions. So obviously it doesn't happen a lot in medical negligence, but it does happen. I once heard Alan Lenczner, one of the founding partners of Risa's firm, talk about notice letters, and he calls them bozo letters because you get a notice letter and you're like, okay, this person doesn't know what they're doing. But if we come across a case...
Anything that ends with govern yourself accordingly is what he would have called a bozo letter, yes.
So we've all had cases where, you know, the retained sponge case, there's a surgery, sponge is left inside the patient, there's a clear medication error, something of that nature that's clear to anyone who looks at the file. This is an obvious case. How would you suggest plaintiff's counsel go about taking those opportunities, sending the letter directly to the physician? How would you suggest they go about doing that to maximize those opportunities?
Yeah, so I mean, I can only speak for my own experience, and I only defend physicians. So I can't speak for what, you know, insurance companies do and that sort of thing, and how you would go about that. But in circumstances where you think there's a clear case of medical negligence, you need to write a letter to the physician. And so don't write to me. I'm not retained yet. Don't write to the CMPA. They're not on until a doctor calls in and requests assistance, and they determine that the doctor is going to be granted assistance. So if you do any of those things, you're just going to get a letter back going, like, this isn't our thing yet. So write to the doctor. You know, set out clearly what it is that you say happened with as much detail as you can. And there should be in the letter a recommendation to the physician that they contact the CMPA so that then the physician gets into the hands of counsel, and then you've got a conversation going. Once that happens, I mean, it's the same as litigation, I would say, but it's even, if what you're looking for is an early settlement before litigation even has to start, your best likelihood of getting that to happen is to be very clear about who you think did something wrong, what you think they did wrong. If it's something that requires expert evidence and you've got it, send it. You know, and a clear articulation of what you think the damages are if you want to have a discussion about that. So it's absolutely an opportunity to discuss it in the clearest of cases, right? If it's a case where there's potentially a defense, then that's not going to happen pre-litigation. But, you know, if there's something that is absolutely clear, then get the doctor into the hands of the CMPA and then counsel, and then, you know, provide as much information as possible so that puts the lawyer in the position of being able to evaluate whether it is indeed a case that is clearly indefensible and ought to be settled. I will also say this. You got to bear in mind that we're not just going to take your word for it. We have a duty to our own clients, which means we need time to investigate. So if you're 2 days from the limitation period and you send a letter like that, it's not likely that it's going to go anywhere. So, you know, you have to provide the information and the time to do a proper, you know, for counsel to do proper due diligence. And then look, if it's clear and we agree with you, then there will be a discussion. If we don't agree with you, then it proceeds to litigation. There's no harm from trying.
Have you, Risa, had opportunities to agree to tolling agreements as part of that process? Is that something that you've used in your practice?
It can happen, for sure. If it's something that you're interested in and you want to canvass, if you think that it may be a case that is that clear, but you're up against it, then again, we can't have a discussion until the physician is in the hands of counsel. So all of that still stands, but it's certainly something, and that's something that I also do at the beginning of litigation sometimes, and we'll talk about this as well when we're talking about communication, but oftentimes I can see just by when the statement of claim was served relative to the limitation period that you probably got retained with very little time to spare. And so the first thing I will do is pick up the phone and say, hey, do you need some time? Because if you do, I'm happy to stand down for a few months while you figure out what you're doing.
Yeah. You also had some thoughts, Risa, about the new rules and what impact the pre-litigation protocol might have on this kind of situation.
Yeah, I mean,
Who knows?
we don't know what's happening yet, but if what happens is some version of what's been circulated, then the pre-litigation protocol is going to result in a lot more of those kind of discussions before the statement of claim is even issued. But even if it's not, there is opportunity for that, provided there's enough information and enough time to evaluate it.
One of the things that I do, particularly once defense counsel's been appointed, and if I know them in particular, but sometimes even if not, it's a good opportunity to first introduce yourself, is once I've served the claim, defense counsel comes on board, sends me an email. Usually it's to request records. I pick up the phone and have a conversation about next steps, about what the file's about. Usually I like to give them at least the opportunity to see the records first, because obviously there's only so much they can do and know based upon the claim. What advice would you have for plaintiff's counsel in terms of those initial communications, the benefit of them, how they can assist with a file moving forward and moving smoothly?
Yeah. So that is my practice as well, especially with the counsel I know well, is to pick up the phone if they haven't first picked up the phone. And the kinds of things I want to talk about are, start with, tell me what the case is about. I mean, all I have is the statement of claim at the moment. By that point, I probably don't even have the record. So if I've connected with the doctor, I probably don't have that much information anyway about what's it about. But what I want to hear is, what's the central issue? Who are the central players here? What do you think is the central issue in the case? Are you ready to go, or do you need some time? What are you focused on? What should I be focused on in looking at it? I mean, if your goal is, I want to move this forward to whatever resolution, whether it's trial or settlement, then the more I know earlier, the faster we're going to get there. If I'm flailing around trying to sift through 20 defendants and I don't have any records, and there are 14 issues that I can discern from the statement of claim, and I don't know what you're focused on, then we're going to be in it for a number of years before we ever get serious. And the more you can tell me at the beginning, the more I can focus my attention, and we can get to some decision about what we're doing with the case. So I said before about the limitation period. One thing that's a real issue, and we see this a lot, is the statement of claim comes in. There are 25 doctors named, 3 hospitals, 47 nurses, and a bunch of other paraprofessionals. I'm looking at that going, it's going to take a year just to get a statement of defense out the door. That's not helpful. And whenever I see that, I hope that it's up against the limitation period, and I will have that conversation to say, what are we doing, and what can we do here to make this more efficient? And so, if you need 6 months to sort of figure out who are the 3 key people you're going against, then take it. I'm happy to give it to you, But if you're really going to make me go, investigate with 20 different doctors and you don't have the records ready for me to go and whatever, we're not going to go anywhere for a very, very long period of time. And I think it's totally counterproductive, no matter what the eventual end of the case is going to be, litigation or resolution. It is going to take much longer.
Yeah. And that sort of leads us right into the next area I want to talk about, which is discoveries. Because in cases, there's certainly been cases where I've had, I'm naming, typically and hopefully you will have done an investigation prior to starting your claim. That's our process for sure. But there are times where you think, there could be some finger pointing between healthcare providers. And so I think it's Dr. A, but there's a potential that there might be something on Dr. B. But I want to examine Dr. A. I want to hear the evidence first because I might not be so worried about the other individual's care, depending upon the circumstances. But when you're getting these claims that have 20 plus players, whether they be doctors and nurses, what would you suggest, and do you have counsel, some wanting to examine absolutely everyone versus a focused examination, maybe without giving up your right to examine the others should it become necessary? What's your thought on that? I like to focus my examinations to the extent possible. I don't necessarily examine everyone. It might change based upon the evidence I hear at discovery. But I like to do very focused examinations. What are your thoughts about that, Risa?
Yeah, so the short answer is I'm for anything that is going to increase efficiency and get us to that sort of inflection point where we know what we're doing with the case sooner rather than later. And so ideally, I would like there to have been, enough investigation that the people are already distilled down to the key people by the time I see the statement of claim. But I also get it. You get retained late, or sometimes you're not exactly sure what the whole story is because you don't have everything that you need, that you might need from discovery, or you're worried that one is going to point the finger at the other. So I get it. There's no judgment about that. But so first, if some additional time will help you distill it down, let's do that. If notwithstanding all of that, we're still left with a lot of people, and it's going to take a long time to go through discoveries. I would hope that we're going to do the discovery of the people you think are the key people first and defer the others till later. And frankly, I do that a lot with plaintiffs as well. If there are a lot of FLA claims, I often just want the key one, who has liability evidence, and I'll kind of leave the rest, if it's going to trial, we'll deal with it later, but we don't have to take a really long time at the beginning if we haven't yet even determined what the outcome is. But certainly, what I don't want is let's discover one person today and another person a month from now, and everybody has a lot of cases on the go, and every time you do it, it's kind of getting your head back into it, and so that brings its own inefficiency. Yes. But doing it in tranches, I think there's no real downside. Getting the key people first allows us all to hear what the key evidence is. And it may, if that reaffirms your belief in your case, great. If it, if you kind of say, oh, you know what, this is not what I thought, then you're going to give up. If I hear the evidence and go, oh, we're in trouble, it's also going to move towards resolution without the need for the other people. Or worst comes to worst, we all hear it and we're like, yep, I have a claim and I say I have a defense. We're no further behind, I think. We've just... we either need the rest of the people or we can cut them loose. Either way, to me, that increases efficiency if we do that.
And speaking of examinations, one of the things I've found really helpful is scheduling those examinations. So this is also something I've had lawyers who are just getting into the medical negligence process say it takes forever to get a defense. It's holding up the entire case. It can take 6 to 12 months. What happened to the 20 days? And I sort of laugh every time. I've never gotten a defense in 20 days. It's never happened. But what I'll do is say to counsel, let's hold some dates. Let's call it 8 months out for examinations for discovery. And in the interim, as long as I get that defense in advance of the discoveries, I'm content to give you as much time as you want. What is your practice in that regard?
So So let me first just address the question of why it takes so long to get a statement of defense. It depends how long it's gonna take to get a defense done, depends on a lot of different factors, okay? So those factors can include the number of doctors, where they are, right? If I'm trying to chase down some fellow who's now back, 10,000 miles away and not on the same time frame and doesn't have any records, and, that can take a long time. What kinds of doctors, like during COVID, if you sued a respirologist, lots of luck. I couldn't even get them to answer the phone. So whether the relevant records are in their possession. So if you're suing a family doctor and it's their chart, that's a lot easier than if you're suing a bunch of doctors who used to be fellows and residents or even staff people at a hospital that they no longer work at. They don't have the records. I got to get the records. What are their computer capabilities? Like, how do I get them to them? It's, and I don't have control over those records. If I'm relying on the hospital or, and that process sometimes takes longer to get into the hands of counsel. I don't have access to the records. And so, all of those factors are factors beyond my control, and I can't kind of get started in even understanding the chronology until all of those things are in place. And here's one other thing, is that even once I get the records, there are sometimes issues where the chronology is not as clear as you might imagine. So I'll give you an easy example, and we've all seen it. So the emergency room, the face page, has the name of a physician as the most responsible physician, but the physician says, I had nothing to do with that patient. And it just means the form was pre-printed and then they weren't on shift anymore or whatever. And so, a lot of times I have to do a lot more digging, and again, that might be through the hospital to get whatever I might need in order to figure that out. And again, it's not something that I have control over. So it's not because we're trying to jerk you around. Sometimes we just don't have the necessary information to get the chronology together so that we can do a proper defense. So that was the first part. The second part was, am I okay with holding dates?
Yeah.
Within reason, yes, okay? There are some plaintiffs' counsel who will start demanding dates the second I surface for the first doctor. I have not spoken to everybody. I don't even know for sure who I'm retained for. I have no sense yet of what the issues are or how long we might need for any of the discoveries. So am I going to insist on we have to wait till the defenses go in? No, but there also has to be reasonability on the other side. Let me at least figure out how many people I'm on for and what the issues are so we can be reasonable about, how long is it going to take to get the information necessary so that we actually can choose wisely as to, how long and when and, how long is it going to take to get prepared.
I think this goes back to, an essential thing that we talked about as we were preparing for this, and that includes trust between counsel and when you start working with the same people. We hear it in the media also all the time about, the CMPA scorched earth. And my experience when I know the lawyers I'm working with and I pick up the phone and I have a conversation, and if Risa tells me, okay, Jen, I can't get a hold of this doctor, they've gone back to the Middle East, we're having some difficulty having an initial conversation. I believe her. We've worked together now enough times that I believe that. And I think that establishing that trust, and we'll get to a little bit more about that as we go on, but even in these preliminary initial steps, having conversations and building relationships with counsel that do defense work, from my perspective, or for Risa's plaintiff counsel, I think is incredibly beneficial to our clients. I think it's beneficial to us as lawyers to have colleagues that we have a positive working relationship with. We spend a lot of time together on these cases. And I happen to know you agree because we've talked about this, but I assume that would, from your perspective as well, is a huge piece.
It's a huge piece, and I'm a big believer in, if you pick up the phone and sort of, if there's an issue, tell me what the issue is. What do you need? What are you looking for? What's the problem that you're trying to solve? And I'll work with you within the bounds of my duties to my own client. You have duties to your client, I have duties to mine.
Right.
But everybody benefits from the case moving forward efficiently. And so anything we can do to work together to achieve that goal is to the benefit of all the clients. And so, you know, I think there's lots of things that we can just solve with open communication. And please don't send me one of those nasty, threatening, like, oh, I'm insisting that blah, blah, blah. Like, that is going to make things take longer. It just does. Pick up the phone and tell me what the issue is, and let's solve it.
Yeah.
Let's
Yeah.
address it.
I also find that communication, like I find out more information about the thinking from counsel and whether they see it generally as defensible or whether at some point we probably can resolve this case just by having those conversations. And that might not be put in writing, but you know, I'll get the, you know what, we can probably get somewhere with this case. You just have to give us more time. If you don't have those conversations, you will not know that. You won't know. And if a lawyer said to me, you know, we see this as defensible, here's the defense, you know, generally that we're making, you know, I don't take that personally. I just know I have more work to do and I got to get my ducks in a row, and we can still have a positive working relationship while taking very different legal positions on a given case.
100%.
So let's move to expert opinions, because post-discovery, obviously we're getting, again, ducks in a row, getting our experts' reports themselves lined up. So I mentioned that it's our process to get our experts before we even issue our statements of claim. We want to know we have viable cases. It's not our approach to hope for the best and do it post-discovery. And you know, there's some firms that work that way, that you know, getting discoveries, getting actual reports later is the process. In the thinking that I've heard from some of these people that, you know, I don't want to spend a ton of money up front. I want to see how strong my case is. I would suggest that's a complete mistake. You're going to waste way more time and money by doing it that way than if you get them early on. So our process, generally speaking, there's some exceptions depending upon, you know, how discoveries go, things like that, is to get our expert reports to defense counsel fairly quickly after discoveries, both damages and liability experts. So I've also heard, though, and I've worked with lawyers who have said, no. The CMPA is going to intentionally delay, and we're not going to serve those reports until 90 days before pretrial. That's our requirement. That's when we're serving those reports, because it's guaranteed to go to trial. So I'm curious, Risa, I think I know what you're going to say, but between those two approaches, what is your thought in terms of, I'm sure you've seen them both in practice, and you also have talked about people that will disclose expert opinions early without prejudice, and I'm curious about how that works as well.
So maybe I'll start there. You know, again, as a function of the trust that exists with counsel who've worked on opposite ends of the file for many years, I certainly have plenty of counsel who in that first conversation will say, listen, without prejudice, I've spoken to, you know, so-and-so. They may identify the person, they may not. Here's sort of the summary of what they say, and I say, thanks, let me look into it. And sometimes it results in me saying, okay, I'm in trouble here, and that leads down one path. Other times I'll phone back and say, you know what, I just spoke to somebody, they have a different perspective on it, on we go. We haven't lost any time, we've just actually sort of helped crystallize what the issue is. You have to have the trust, though, right? You have to know that it's a without prejudice conversation. There was one guy who used to actually send me his opinions, like literally as soon as I appeared on the thing. I mean, I think most counsel are reluctant to do that before discovery. I certainly am reluctant to serve anything before discovery. I might serve causation if I think it is absolutely clear and the case is not going anywhere. I think for standard of practice, most people on both sides want to hear the evidence before they have somebody, commit to something in writing. But I think, those conversations, whether you serve the opinion or not, if you've got it and it helps the conversation and it helps focus the other side, then I think that leads to efficiency. So I certainly have encountered plaintiffs' counsel who will serve gigantic piles of reports on the last possible day, It often includes reports that have dates from years beforehand. I don't understand it. I've asked about it. I think there is some, kind of like the guy you started with, there's some sense that if I have it 1 minute earlier than I'm entitled to it, that I am not even sure I can articulate what they think I'm going to do with it. It's going to give me more time to think of a defense. Like, I don't know. I guess that must be the viewpoint. I don't see the wisdom of that. If there's a defense out there, I'm going to use it. If there isn't a defense, it's going to get settled. The only thing that holding reports that you have in your hand for, and not doing anything is it just stalls the case, right? I don't know what the issues are. It means you're not going to get my reports until later. And whether it goes to trial or settles, it's just going to take much longer. So I don't get that if your goal is to head to resolution earlier. And look, do I, as a matter of strategy, hold my reports that I have in my pocket? No, I don't know what the benefit of that would be. I have the same struggles that you have, which is that we're all swimming in the same pool. The people are busy. It's not always easy to nail them down. Sometimes it turns out that we've been focusing on the wrong issue, and then I get your report and I got to sort of reframe the question. But from my perspective, you tell me what your case is, I tell you what my case is, and then we'll see where we go. I don't think anybody benefits from holding things back. Maybe there are some, limited circumstances where there might be a reason, but I don't, generally not.
Let's talk about specific experts for a minute. Mm-hmm. I'm sure that there are experts that you identify as, and I'm going to focus this to liability for this question, but that do more plaintiff work or exclusively. Yeah. How much, so if I tell you I've got an expert opinion, here's what it says, here's what it's from, how much weight does that hold for you in terms of your next steps in the file?
So I think that everybody on both sides nowadays has to be that much more cognizant. It's less about, am I going to be persuaded by it, but it's more, how's it going to play in court? If it's somebody who is, clearly a hack for one side or the other, that's going to be a problem in the way the courts are treating these experts. And so, that is going to be something that I am going to observe the same way you would observe it about any of the reports that I would serve. And so I think that we all have to be encouraging experts to be working on both sides for their own credibility. And that also means that when we are evaluating each other's cases, that's one of the very many factors that we're going to take into account in evaluating those expert opinions, including whether they're appropriate experts for the circumstances. Do they do what they are purporting to opine on? Are they adequately educated? Are they senior enough? Do they come from the right institution? But also, are they actually unbiased? And are they likely to be perceived as unbiased? So we do the same evaluation that you would do. Does that answer the question?
It does. We have a recent experience where we're actually using a joint future care expert between defense and plaintiff. So it's a current experiment. We're going to see how it goes. We haven't gotten quite to the reporting stage. Is that something you've contemplated on damages, of course? And would it be something you're willing to do, certain counsel? What are your thoughts about that?
I think I would have to evaluate it on a case-by-case basis, and I think it depends on what the issues are and who the person is. I think that I often see damages reports that look like cookie cutter. Everybody, no matter what their level of functioning, needs 24-hour-a-day care. And of course, there are plenty of cases where that is necessary, but it's almost like there isn't a thought process that goes into whether that's appropriate or not. So those kinds of experts are obviously, there's no way those people could be retained jointly. I would hope that we would be able to find people who operate on both sides, who have the credibility with both plaintiff's bar and defense bar, where we could do it. I think it also depends on what the issue is, right? Certainly, we should be able to jointly agree on what the multipliers are. You know, there are lots of things where we don't need, there should be just an answer, not kind of an opinion about it. And so I think there are things where we should be able to agree and hopefully find somebody joint. But, you know, there are some issues that are more contentious that it's harder.
Right.
But open to trying.
I want to ask you about a sort of case-specific challenge. This is a nice, light, easy question for you. Okay. Sometimes we see cases that get stalled, not because there isn't liability, but because it's a very difficult liability split to figure out. So there might be doctor, midwife, nurse, doctor, nurse, potentially several different doctors. Maybe that's a little less of a problem because it can be one pot. But how would you suggest plaintiff's counsel can assist the defense side in figuring that out? Because from our perspective, there's times when we just say, one of you is responsible and you can decide, but that tends to stall things. And so I'm curious what, if any, advice you would have.
Yeah, so I think you have to break down that category into a few different categories. So if it's clear that everybody has some liability and that, you know, the goal is to settle with the plaintiff, but we just haven't sorted out what the apportionment is, that's a simpler solution. And I would say with that, just give the defense the time it needs to sort that out. Because if you end up at a mediation and everybody, like, you're not getting instructions on the defense side from one person and everybody has to go back to their own instructing person, it becomes, what ends up happening, frankly, is you sit in a room for 8 hours
Yes.
while everything else is going on. And you have to recognize that, like, different, the institutions with the money may have different approaches, some to apportionment. Some may want to sort of say, I want to agree on the percentage split in advance, and then however it goes, it goes. Others say, I want to be committed on a particular amount of money, and those, it's not easy to reconcile that, right? So, you know, I think it's most efficient for you if you sort of say, I'm going to stand back while you guys sort it out, and then when you're ready with a collective position, you know, then we'll have something to talk about. And I think although that may build, you know, a few months into it and it may seem like it's delayed, it's actually more efficient for your side at the end of the day if you do that. It's more complicated where there isn't agreement, you know, about whether everybody is liable. Like, one person may think the other person is liable. The other person may think they're liable. One person may think nobody on the defense side is liable, and the other side may think that everybody is. And so, you know, that's more complicated to work out. I think, you know, the advice, again, is probably the same, which is you are going to benefit from just backing up and kind of letting us work it out. I think they're also, again, I mean, I feel like I keep coming back to the same refrain, which is there's a degree of trust that is going to govern this, right? If you're like, why is this case stalled? If you're somebody I trust, then I may have that conversation that says, look, I got my own internal problems here that I have to sort out. Just give me a little bit to try to get it worked out. But I think, you know, it can be very complicated. And, you know, bear in mind also that there are, you know, there are co-defendants that end up co-defendants together in a lot of cases where these discussions happen all the time. And so there's also that kind of trust relationship where we can have those conversations. In other cases, there are times when we're dealing with people we don't know, you know, product liability people or pharmacies or whatever. And so those are harder to sort of engage in those discussions because those relationships are not there. So, you know, how long it takes, you only see your part of it, but there may be a whole other thing that's going on that, that has to be dealt with. So I think you are better off to sort of allow that to play out without trying to get in the middle of that.
And in terms of those same like defense dynamics, what about conflicts, particularly obviously your experience being representing physicians? There are times when, as plaintiff counsel, we think this is a clear conflict. Is it helpful to you in any way? And I don't mean obviously this in a paternalistic way, but like to put it in writing so your clients can also appreciate that, to say, we believe this to be a conflict, or is it really a completely 100% internal decision when a doctor gets referred out to external counsel?
I'm not sure I follow. What do you mean a conflict?
Between doctors.
So, I mean, look, we're always alert to the possibility of conflict, and if there is a conflict, then there's going to be separate counsel. I think if there's something that you're seeing that I haven't seen, pick up the phone and talk to me about it and let me know. Maybe it's something I didn't notice, or if there's something right up front that you think. But, I mean, otherwise, it's something that's always on the radar screen. So it's not like we're just motoring on with, going, yes, this is a conflict, but I'm going to do it anyway.
Do it anyways, right.
Yeah.
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 Before we open it up to the audience, see if anybody has any questions, is there anything else we haven't covered that you think, Risa, in terms of an audience that has more plaintiff lawyers here, would be helpful from your perspective in terms of getting these cases moving? We obviously heard about Dr. Pott's experience and wanting for our clients to, in the cases that it's possible, sometimes a trial is necessary, that's just how it is, but that these cases can be run more smoothly through counsel intervention.
Yeah, I mean, I think that, again, it comes back to open communication, building those relationships of trust. I think a lot of people think it's counterintuitive that I somehow have to be your enemy, and it's not the case. I think you're doing a service to your client if your relationships with defense counsel are good and you have that open line of communication where if there's a problem, you can pick up the phone and say, listen, I've got this is my problem, what can we do? And and I have the same freedom to call you and say the same thing. And sometimes it's I need time, sometimes it's you need time, or my client is very upset, we need to get a mediation scheduled. Okay, let's get it scheduled. It's not, I'm not looking to make your life as counsel difficult. My interest is in moving the case forward toward whatever the end is going to be. It doesn't serve anyone's interest for a case to go on for, a double-digit number of years. That's not the goal for anybody, and it doesn't serve anybody's interest. And trust me, the physicians don't want that either. They don't want this hanging over their head. Whatever the outcome is, they want it over.
Yeah.
So, and that's, that is, I think, the mandate. Let's get it moving forward.
So, Charles.
The myth that when you settle a case, the release has to say $0. We've been told, or I guess I've learned through the time, or whatever it is.
$2 now.
$2 is because that avoids the reporting of the doctor to the college. Is that a myth? Can you clarify that?
No. Our traditional release, if money is being paid on behalf of a doctor, is that it will say $2 plus good and other valuable consideration, because that's all that's required. And it typically will have a confidentiality clause as well. But that has nothing to do with the reporting obligations. The regulatory reporting obligations exist. And frankly, they exist as it currently stands, whether money is being paid on behalf of a doctor. It even exists for the doctors who are being released at the same time. If they're aware of a settlement being made, even on behalf of a non-doctor co-defendant, they have to report that it happened. I'm not sure I understand why, but that's the view that we've been told from the CPSO. Yeah, it's not connected to the $2 thing.
Easy question.
Yeah. Anyone else have any questions for Risa or myself?
Penta?
So sometimes we go to trial and the reports from the defense seem a bit equivocal, not the strongest. How often is the decision to go to trial or get as close to trial as possible physician-driven versus recommendations for settlement? Or it could go either way.
So, I mean, look, the recommendation to go to trial or not, and the decisions that are ultimately made are made based on all sorts of factors, you know, and it will include all the things you would expect: the facts of the case, the strength of the expert, the anticipated witnesses, and what we expect is going to be the credibility, what the doctors want or don't want, although that's, you know, really only one factor. But I can't sort of say it's more this or more that. You're looking at it holistically the same way. I mean, it may be a bit different for, I guess, on the plaintiff side, but we're taking everything into account the same way we would in any case, which is to say this is what we think is the likelihood of succeeding in the case. And you know, the mandate is defend the defensible. It doesn't mean that, you know, we're going to lose some cases. We're going to win many cases because we settle a lot of cases. And so, you know, the ideal is to get the cases that should go to trial to go to trial. You know, but that's based on a whole host of factors.
I have another question.
Okay.
You're lovely to work with, obviously. You're one of my first mentors in this area, so thank you for being here. But we heard stories about very difficult counsel, and we've all dealt with very difficult counsel. What advice do you have to plaintiffs' counsel to try and collaborate, notwithstanding that the person on the other side is not someone that seems very collaborative?
What advice do you have for me in dealing with difficult plaintiffs' counsel? I say that only half facetiously, right? It's not something that's unique to one side or the other. Difficult counsel or difficult counsel, you know, and we all deal with them. It's frustrating and annoying. And I think it's not also unique to medical cases. It's true for those of us who also practice in other areas. Difficult people are difficult people, and you know, so what do? You keep trying to be civilized and to pick up the phone and to, you know, take a collaborative, problem-solving, efficiency-based approach. With some people, it's impossible, and you know, it's very frustrating. But we all have people we have to put up with, you know. But you hope that the vast majority are not like that, and I think you have to just. What I would say and what I say to the young associates in the firm is don't descend to that level.
Yeah.
And it is really hard. It is really hard.
Yes.
Because when you're getting bombarded with, you know, you did this and you did this and you didn't do that and unreasonable demands and not doing anything to, you know, uphold their own obligations, you know, it's very easy to want to descend into writing some nasty thing back. And so, you know, the same thing that you would tell a junior, like take a beat, hold that email on your screen for 24 hours until you calm down, and then try again to pick up the phone and hope that you can break through some of the nonsense.
Yeah. I'm going to add to that for the junior lawyers in the room that, and not Risa's firm, but another medical negligence defense firm that some of the junior lawyers, like I've had really difficult experiences with, where I just get these nasty emails that just do not seem civil at all, overly aggressive, positions that seem so extreme, that make, I have drafted back those response emails and then thought, okay, stop this for a second. And both times recently, I've picked up the phone and said, let's have a conversation. One time was the conversation, the other one was at Discoveries. I had a conversation with this young lawyer and she was like, I'm really sorry about the tone of my emails. I ran these drafts by somebody else and you're really lovely and I'm so sorry that I was so aggressive in my written communication. Most of the time, not always, are just difficult people, but it goes back to starting those relationships early. And from myself as a more senior lawyer, when I established then that relationship with them early on, and they say, oh, okay, she's a normal person who's not going to respond in the way perhaps they've had a different experience, it sets a different tone. And again, it goes back to, I think I get better communication from them. My job is more enjoyable because I have a better working relationship with these lawyers. And I think it makes a huge difference.
I'll tell you
sure.
something, it's a good question. We just did a program, an education program in the firm for the young lawyers titled How to Deal with Difficult Counsel, because I think they struggle with that. Mm-hmm. And a lot of it was all these things that I was talking about. And it's funny, now that we're in the post-COVID, everybody does everything by Teams and Zoom and whatever, I would encourage not just picking up the phone, but use the video.
See the face.
It's harder for someone to be a jerk when they're looking at you face to face. Don't you find? And it just, so have a conversation face to face and just say, like, please stop sending me this. What is it that you need? Let me tell you what I need, and let's try to have a conversation and work to get it across the finish line, and don't send me, but with some people, you do that and it settles it down for 3 or 4 days, and then it starts again with the emails.
And remember, don't take it personally. That's always my advice to anyone. It's rarely personal.
I think that there are some people who have this notion that that's what it means to be a good lawyer. That sort of unnecessary aggression and, being like sort of pushing these personal attacks against the other lawyer. I would love to sort of reframe people's reference so they get that it doesn't mean you're weak or unskilled if you actually are civilized, and you're more likely to get things moving faster if you're just human about it.
Yeah, I agree. I love ending on that note. I don't know where we are with time, so probably. Excellent. Risa, I just want to thank Risa as well. I mean, obviously a tough act to follow with a chat about how difficult the process can be for plaintiffs. So, thank you so much for being here, Risa. It is very appreciated.